All right. Hello, my friends. Hello. Hello and welcome. I'm Otis Landerholm. It's good to see you here. And I am here with a little bit of it's a bummer. It's a bummer. I got a bummer of a case that just came down. This is the case of Sanchez versus Mayorkas. And it was decided today, June 7th, 2021, by the United States Supreme Court. And so here's the issue, all right? The issue is that when somebody's applying for a green card, there are three things that they got to show, all right? First, they've got to show that they were inspected and admitted or paroled into the United States. Second, they got to show they've got a bona fide marriage or a bona fide relationship to someone who can petition them, maybe a U.S. citizen, spouse, parent, or child. And then the third is they've got to show they're admissible. All right. Those are typically the three big requirements for like applying for a marriage-based green card. All right. So what is this case talking about? This case is talking about people that got TPS. So if you're from El Salvador, if you're from one of the other countries that was granted TPS, listen up. TPS, the argument, it was a creative argument. I loved the argument. I was hoping that this argument would work. The argument was that when somebody is granted TPS, temporary protected status, that could constitute being inspected and admitted. All right. After all, when you put a TPS application together, you are submitting documents to immigration. You're asking them to approve your application for status in the U.S. And so it's akin to, some might argue, similar to applying for an admission into the U.S. But what the U.S. Supreme Court decided today, and yes, they decided it unanimously, all 9 of the U.S. Supreme Court justices decided that, unfortunately, they're kind of like, nice try, but unfortunately, TPS is a temporary benefit only. It is not a quote unquote admission. It does not give someone the standing, the ability to then apply for a green card here in the U.S., to apply for adjustment of status here in the U.S. Without showing some other inspection and admission or parole into the U.S. All right. And so that is what I wanted to say about this video. Yes, it is disappointing. And we were hopeful that the law could have gone the other way and the Supreme Court could have gone the other way. But the bottom line and really the punchline of this case is that ultimately the issue goes back to Congress. All right. Our immigration laws are broken. Our immigration laws are like, there's so many people that are here in the U.S. that cannot fix their case. All right. And they can't do anything and that are stuck in administrative limbo. And so, really Congress needs to be the one. I guess the Supreme Court decided they can't do it for folks that were granted TPS status. And so really it's Congress that has to change the law in order to give people from who have been granted TPS the ability or the standing or the right to file for green cards. All right. So hope this was helpful. Sorry for all of those who had TPS who were crossing their fingers and hoping for a different decision here today. But this is what the Supreme Court decided. It's important to understand it. If you have questions about it or how it might affect your case, please feel free to contact our office. Thank you so much for being with me. I'm Otis Landerholm, Landerholm Immigration, A.P.C, where we fight for your American dream. All right. Thank you. Bye-bye.